It's a great pleasure to be here at the Al-Mahdi Institute. Um, I've been interested in this topic for well over 15 years, and I published my analysis in the Modern Law Review, which is based at the London School of Economics, in 2014, an article called Accommodating Religious Beliefs. Subtitle Harm, Clothing or Symbols, and Refusals to Serve Others. Um, so the overriding principle was that religious beliefs should generally be accommodated unless they affected the rights of others. That's the harm part. And so in most cases of clothing or symbols, I thought that there should be accommodation, but with refusals to serve others, often this would involve discrimination and could often not be allowed. So a hypothetical example, if a bus driver in Birmingham posts a list of the people who can go on his or her bus, I serve the following groups in society, ethnic and religious. Well, it's a public bus service. Everyone has to be going. So regardless of the individual's beliefs, they cannot deploy them or try to act on them in the workplace. So on the refusals to serve others. So what I looked at was the case law of the European Court of Human Rights, in particular on Muslim women wearing hijab. And there was a case in 2013, which I'll mention later, Awida and others versus United Kingdom, about two of the applicants wanted to wear visible crosses in the workplace. One worked for British Airways, the other in the National Health Service. And the other two cases involved Christians refusing to serve same-sex couples. One of them was Lillian Liddell, who was a marriage registrar in the London Borough of Islington. Her job was initially a marriage registrar, and she was told, your job has changed now, you're a marriage and civil partnership registrar, and you have to register the relationships of same-sex couples. And she refused to do so because of her Christian beliefs. Eventually, she was dismissed. She lost in the UK courts, and she lost in the European Court of Human Rights. So that was the context for my article. So if you want the detail of my arguments and you're able to get online access, that's the place to go. So my first subheading is Majority Acceptance of Visible Muslim Diversity. And our story really begins in Birmingham. So for British human rights and anti-discrimination lawyers, Mandla versus Dowley is a famous case, which was decided in 1983. It effectively settled the debate in the United Kingdom. And we're quite puzzled when we see the problems in France, because this has not been an issue here for many years. And it arose in the context of a Sikh boy at an independent school, about a 9-minute drive from here, Park Grove School. It might no longer be open. It might have been a Church of England independent school. I'd have to check. But in any case, the issue was the school uniform. So the Sikh boy said, I need to wear my turban to school. And the head of the school said, well, the school rules would either, I suppose, require a bare head or the school cap, but definitely not a turban. And they said, no, you can't wear your turban here. So in terms of the facts of the case, apparently he found another school that would accept his turban, and that was the end of the matter for him and his father. But the Commission for Racial Equality, which is now part of being absorbed into the Equality and Human Rights Commission, they took the case and paid for the lawyers because there was an important principle at stake. And it went all the way to the House of Lords, which in 2009 became the Supreme Court of the United Kingdom. And the way it was analyzed was as indirect discrimination against members of a racial group. So the school didn't have a rule that said no Sikhs. That would have been direct discrimination. But they had a neutral rule that said no headwear, not part of the school uniform. But that had a disproportionate effect on Sikhs, or it could have been any other religious group. Oh, actually, sorry, that's an important part of the case. Had to be a racial group at the time, because at this time, 1983, discrimination based on religion was legal in Great Britain. Not Northern Ireland, it was prohibited in 1978. Great Britain, 2003. That's the piecemeal approach that the UK Parliament takes to human rights issues. But in any case, they decided that Sikhs are a racial group as well as a religious group. So the two groups in this position are Sikhs and Jews, because most of the members of the group have a common descent, and conversions are exceptional. So this benefited Sikhs and Jews at the time. It was not good for Muslims or Christian minorities, such as Roman Catholics, who were much more ethnically diverse. And so this analysis would not work for them. Okay, so by 5-0, the House of Lords said unanimously this is indirect racial discrimination. Important part of the reasoning was the Race Relations Act at the time said the question was whether people of this group can comply with the rule. And they said, well, that must mean can comply, consistent with your culture. So it was irrelevant that he could physically remove his turban, but he could not do so consistent with his culture or religion. So that essentially settled the issue for the United Kingdom. The same reasoning would apply to hijabs, although at the time you couldn't argue direct or indirect discrimination against Muslims because religion was not in the legislation. You would have had to link it to an ethnic group. So you could say people of Pakistani, Bangladeshi origin, any country with a Muslim majority. That was fixed in 2003 when the legislation was changed. So that's generally been the pattern in the United Kingdom. Two exceptional cases. One is the Shabina Begum case, which involved a jilbab. And personally, I think this case was wrongly decided by the House of Lords. In the 1990s, I had a student in human rights law who wore a jilbab. And she did very well. She went on to get a distinction in her master's. She got a training contract with Clifford Chance, one of the largest law firms in the world, and her clothing was completely irrelevant. But what happened in this case, the school had an accommodation. One of their uniforms was a shalwar kameez. And Shabina Begum said, no, that garment is too revealing, showing the shape of the body. I want this cloak. And the House of Lords said, well, the school has gone far enough. They don't have to do any more. She could go to another school, which is never, or almost never, a good argument in anti-discrimination law, because we don't accept it if we have a restaurant that says no Muslims, and the restaurant says, but the restaurant down the street will serve you. The question is usually your right to the specific opportunity. And she wanted to study at a specific school. So that's an exceptional case. And the other issue is the niqab, or face covering, which is certainly legal in the street in the UK. And but the question arises in employment. Can it be a problem in specific jobs? The ASME case involved a support worker in the classroom who was supposed to follow what the teacher was saying and then whisper to students having trouble with language and help them with their studies. And it was thought that she could not do this effectively with her face covered. So you could say in the UK that a niqab is a case-by-case assessment, really, of the effects on others. Is it interfering with your job? So Canada, I'm pleased to say, I grew up in Canada and studied law there, had a similar, well, it wasn't solved in the 1980s by a court case, but it was a debate about the Royal Canadian Mounted Police. And if you're familiar with them, they have a traditional hat with a flat brim. And there was a Sikh man who wanted to join, and this caused outrage. The thought that he would wear his turban and not wear the traditional hat. And eventually he was allowed to join, and people got over it. And today you would see police officers with women wearing hijabs in most of the country, etc. So I would say socially and politically, that was the turning point in Canada. Later, you had a decision of the Supreme Court in the Multani case, where the issue was a kirpan, ceremonial dagger that some Sikh men wear under their clothing. And could this be worn in school? So again, not the rule in the school doesn't say no Sikhs may study here. It says no weapons in school. And that would tend to exclude Sikh men disproportionately. The key fact in the case that there was not a single report of an incident involving a kirpan. In Canada, there was no report that it had ever been used to harm someone. So that was decisive for the Supreme Court. And they actually, that case came from a school in Montreal, in Quebec. And since then, there's been a lot of opposition to visible religious diversity. So the United States is quite similar. A case in 2015 went to the U.S. Supreme Court involving Abercrombie and Fitch clothing store. I don't know if you're familiar with them, but they have they had kind of beautiful models, let's say, in their advertising, a very clear image of the model, which was the kind of customer they wanted to attract, etc. And there was actually a case in the UK where they rejected a woman who had a prosthetic arm, so she had a disability. And they said that's not our image, and she challenged it, and she won. And in this case, the woman, she got the job as a sales assistant, and then she started wearing her hijab at work, and they dismissed her. And she won her case in the U.S. Supreme Court. South Africa, the Constitutional Court has a case involving a Hindu female student wearing a gold stud in her nose. So, and most importantly for Europe, in 2015, although there are inconsistent decisions in Germany, but the Federal Constitutional Court ruled that teachers in schools, Muslim women teachers, have a right to wear a hijab. So these are all the good examples. Now, if we turn to what I call majority intolerance of visible Muslim diversity, the leading case is France. And I suppose to understand what the problem in France is to compare their analysis with the Mandela case. So the idea of indirect discrimination was introduced into UK law in 1975 and 1976. And that means it's an acknowledgement that society is diverse. There are different groups in society, and neutral rules may have a different impact on different groups. In France, they have a big problem with the idea of groups in society. They call them communautés, and they think that they're contrary to the French Revolution. the French Revolution established the French Republic of equal citizens, and that's that. And there's no need to acknowledge the existence of different ethnic or religious groups in society. So, so that's why they have trouble with the concept of indirect discrimination, and actually they've been forced to introduce it in their law through the European Union. But in any case, once hijabs in schools became an issue, they passed a law banning them in 2004. But the target really is Muslim girls, but they don't want to appear to be discriminating, so they apply it across the board. So Sikh turbans, Jewish skull caps would all be prohibited. Christian crosses are debatable. It seems to depend on how big they are. Yeah, so it's the opposite of the Mandela decision in France. Then in 2010, they passed a law prohibiting people from covering their faces in public, with a list of exceptions. Notably, for example, Christian holidays when people wear carnival masks. And I believe there's one for motorcycle helmets, et cetera, et cetera. So really, their concern was Muslim women covering their faces, but they drafted it in a way so they didn't appear to be the target. So that law was challenged, and sadly, I'm jumping ahead. So yeah, first they went for hijab, then niqab, and then in 2014 you get a decision from the highest civil court on a private sector situation. So the justification in France for the restrictions on hijabs in schools, and that they also apply to civil servants, is that France is a secular republic, and that anyone who brings religious clothing or a symbol into a public space, in the sense of government space, a government-run school, government office, is creating a conflict between religion and the secular state. So that's the way they look at it in France. But in this case, in 2014, they applied similar reasoning to a private nursery. Okay, the nursery was not the state. So there's no clash between religion and the state. So really, I'd have to read the judgment. I think what may have crept in there, and we'll see it in the next case, is the influence of the hijab on the young children. So don't quote me on that. I'd have to check that. But okay, so let's go to the European Court of Human Rights. Now, what the court, in its reasoning, it tends to follow is European consensus. So they tend to identify the majority trend in Europe and then say, that this is now a minimum European standard, which every country has to meet. So the first time they came across the hijab was a case from Switzerland, Dahlab, a primary school teacher. And I teach this to my students every year and draw attention to this language, which I think is insulting and a stain on the record of the court. So they describe the hijab as a powerful external symbol. In a later case in 2011, they call a Roman Catholic crucifix on the wall of a state school classroom in Italy a passive symbol. So that symbol would have no effect on the students, whereas here, it was putting the students at risk. At risk of what? Well, they say it cannot be denied that this headscarf might have some kind of proselytizing effect. Okay, I think this is just crazy. Proselytizing is when a teacher departs from the curriculum and says, today we're not doing arithmetic, we're going to discuss my religion. I am Muslim, my religion is the best, and I want you to go home and tell your parents that they need to convert. Okay, that would be proselytizing, and the teacher could be disciplined for that. But wearing clothing associated with religion is silent. It's a personal symbol. It's not proselytizing. And the fact that it's in a state school does not mean the state is endorsing it. It merely means that in the school, among the staff, you see the same diversity as in the street and on public transport. So, and they said the headscarf difficult to reconcile with the message of tolerance, respect for others, and equality. So I'd say that's the low point in the court's case law. Now, this was not a judgment, and they didn't necessarily have to follow that case, but in a case from Turkey in 2005, a medical student at Istanbul University not allowed to wear hijab, they decided by 16-1 that Turkey could do this. A woman from Belgium dissented. She said this is an adult woman and she should be able to make her own choices. To be consistent, they applied this reasoning to a Sikh man. France did not want him to wear his turban for his driver's license photo, which again seems crazy because when he drives his car, he wears his turban. So that would seem helpful to the police officer to identify him. They upheld the French ban on hijabs in schools. And then 2014, the law on face covering is challenged. And this was a perfect chance for the court to say, no, France, you've gone too far this time. At the time, only 2 countries in Europe had laws of this kind, France and Belgium. They could have easily said, European consensus is that this kind of law is not necessary. But instead, they accepted the reasoning, the argument of the French government was there is an obligation to live together in society. If you cover your face in the street, you're cutting yourself off from society. Which, I mean, I think if you compare it with other ways you could cut it yourself off in the street with big sunglasses, a hoodie, earphones, etc. Personally, I don't think there's any obligation to engage with other people in the street. And the vote was 15-2. 2 women judges, one from Germany, one from Sweden, they dissented. So this is the pattern in the case law. The following year, 2015, we get a case, Ebrahimian versus France, a Muslim female employee of a public hospital not allowed to wear a hijab. Now this creates an anomaly in the court's case law because in 2013 we had the Awida case. A Christian check-in agent for British Airways at Heathrow had been told she could not wear a visible cross, and the court found a violation of her right to manifest her religion in the workplace. So I think one way to reconcile this would be to say that really the problem in Awida was that British Airways was inconsistent. They allowed hijabs, turbans, Jewish skull caps, but not Christian crosses. Whereas in France, they tend to be very consistent. They prohibit everything. Okay, so France, the French approach has been allowed by the European Court of Human Rights. I have a theory about this, which is that the judges of the European Court of Human Rights live in France, mostly in the city of Strasbourg in eastern France. So they are very well aware of what's a sensitive political issue in France, and they tend to avoid them. Now, the approach in Strasbourg has affected the Court of Justice of the European Union in Luxembourg, which has also permitted the French approach, with one exception in the Asma Bougnaoui case. They said it can't be based on the customer's objection. So in that case, a woman wearing a hijab was sent out to work at a customer's office, and the customer said, we don't like her hijab. And they told her she shouldn't wear it. So they said, that must not be the reason. It must be the company's own policy. So that's France. And fortunately, this has had an influence on the province of Quebec in Canada. I lived there for 5 years. I did a year in a university in Quebec City. I did 4 years of law in Montreal. And it's somewhat for similar reasons. In Quebec in the 1970s, they passed a law prohibiting commercial signs in English. A business could not have a sign in English. Everything had to be in French. Signs in English were seen as a threat at the time. Eventually, they changed a law so that you could use another language. But the threat in the year 2010 and on became visible Muslim diversity. And it's not because of the French Revolution, which didn't apply to Quebec, but they had what they called the Quiet Revolution in the 1960s. Quebec used to be a very religious society dominated by the Roman Catholic Church, and it gradually became one of the least religious places in the world. And so a lot of people think, well, we got rid of Christianity. And now these immigrants are bringing religion back into the public space, and we don't like it. I had a big argument with a gay activist in Montreal, and I said, well, you don't like seeing a hijab. There are people in Russia who don't like seeing a rainbow flag. And he said, no, that's completely different. So some people, they like to protect their own diversity, but not the diversity of others. So I always put this in the readings for my student, this job advertisement. So at the time, this was published at the time of when the debate in Quebec was starting. And so a hospital in the Toronto area advertised and said, we don't care what's on your head, we care what's in it, which I thought was a very effective slogan. So, in 2019, Quebec passed a law. It's not as strict as in France. In France, no civil servant can wear religious clothing or symbols, even if you're working in a back office away from the public. In Quebec, they've done it for people in a position of authority, so in particular police officers and teachers. And this is now being challenged. The hearing was held last week, a 4-day hearing in the Supreme Court of Canada. And basically, Quebec should lose. This is clearly contrary to the case law of the court. Look at the Multani case on the ceremonial dagger. But Quebec has invoked an exception in the Canadian Charter of Rights. It's called Section 33, which allows them to pass laws that conflict with charter rights. The exception lasts for 5 years at a time and then has to be reenacted. And that's what they did in 2019. In fact, good question, it would have expired in 2024. They must have extended it. So my feeling is that they will lose. Quebec will win in the Supreme Court. They will say, we would like to help, but we can't under the Canadian Constitution. So the case will then go to the United Nations Human Rights Committee, which is what happened to the case about the ban on languages other than French. Canada lost in the UN Human Rights Committee, and Quebec changed the law. So I'm hoping that's what will happen here. The UN Human Rights Committee has consistently ruled against France. France doesn't care because they say the European Court of Human Rights is on our side, so they just ignore the UN Human Rights Committee. Canada would take this more seriously, so I would hope that eventually the law will be changed. Okay, so that's my first topic. Now, my overall title was Give and Take in Christian Majority Countries. Give and take is an English expression. It's not clear who's doing the giving and who's doing the taking, but the idea is flexibility, compromise. So the Christian majority needs to get used to customs that are not theirs and that do not affect anyone else and should be accepted. But Muslim minorities also find themselves with new customs that are unfamiliar. So same-sex marriage is my example here. As of today, we have 38 countries in the world that allow same-sex couples to marry. It's almost 20% of United Nations member states. Of these, 36 have a Christian majority, and Taiwan has a Buddhist Taoist majority, Thailand a Buddhist majority. So, same-sex marriage tends to be seen as the achievement of full legal equality. At the opposite extreme, you have a criminal law, sometimes coupled with a death penalty. And so Christian majority countries with criminal laws include Jamaica, Trinidad in the Caribbean, in Africa, Ghana, Nigeria, Uganda, Kenya. Among Muslim majority countries, unfortunately, they all criminalize except Albania, Bahrain, Jordan, Turkey. Indonesia did not criminalize for many years, but they have just adopted a new criminal code which says that all sexual activity outside of marriage between a man and a woman is illegal. So this is the map of criminalization. You see, there are no criminal laws in North and South America except former British colonies in the Caribbean, none in Europe, fewer in East Asia, except for the new one in Indonesia. So mainly Muslim and Christian majority countries in the Middle East and Africa. India, the Supreme Court decriminalized in a decision in 2018. And at one point I did a calculation, roughly 1/3 of countries have some form of protection or recognition, meaning an anti-discrimination law or marriage or an alternative for same-sex couples. 1/3 have criminal laws, and then there's 1/3 in the middle that don't have a criminal law, but they don't have any protection or recognition. So big countries in this category are China, India, Russia, Turkey. Okay, so I'll try and go through this quickly, but there's question of Muslim acceptance of secular same-sex marriage. So what happens? Muslim parents in Britain, one of their children comes home, a man says, I want to marry another man, a woman wants to marry another woman. What is the reaction? Let me just show you this film clip from 1999. It's his oldest son's wedding day in Greater Manchester. Man of Pakistani origin married to an English woman.
That's right. Tradition sees, son. All our people wearing this. Save your name in Arabic. That's it.
You two pack it in now or I'll wipe the floor with the pair of you. Mina, veil on. Sajid, you go and get those things. Get that bleeding Parker off. Mania, move it. Well, Tarek, Salim, let's have a look again. Absolutely.
Your son.
Sellotape. Sellotape. Plenty sellotape. 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 Look at that. Pick him, Eddie. Fucking fake.
Saj, Hello, Dennis. See you later.
What you fucking grinning at?
Big Granddad. It's not funny, that song.
Sure, ask what I hear. You want that song? How do this little light? The seat light. Sorry, no. I can't have everything okay. Sorry, Dad. Why you was do this thing to me and bring a shame on my family? I don't understand. No understand. Maybe I should have taken family to bed for a long time ago. Or Pakistani there, see? Know this problem.
It will always be difficult for you, Zaid. They're different.
I thought that would best illustrate my second topic. So the choice for Muslim parents is to accept or reject their lesbian and gay children. If they pressure them to enter an opposite-sex marriage, which they don't want, which I would say is the pattern in most of the world, including most Muslim-majority countries, but not just Muslim, Hindu majority, India, you'd find the same pattern, China, Japan, etc. The end result is two unhappy people. The spouse that doesn't want to be in the marriage and the other spouse who feels disappointed that the spouse cannot love them the way they want or doesn't feel the strong attraction that they would like. So considering that we're talking about possibly 2% of the population in any country, there are lesbian women and gay men in every Muslim majority country, not just in the Muslim communities in Britain. I've met them from Iran, from Saudi Arabia, etc. So I think the initial challenge is to accept the child's difference and what's better for the child. Parents want their children to be happy. So I hope that eventually some parents would accept this. Some sign of change I've indicated. I have, you can watch them in your own time, 3 Bollywood films since the decriminalization in 2018. The first one involves a woman who doesn't want to marry a man. She has a girlfriend. Second one, a man with a boyfriend. He tells his parents. They insist, no, you have to marry a woman. The third one in 2022 is has a gay police officer who meets a lesbian physical education teacher, and he says, let's get married and please our families. And they do get married, but then complications ensue, and it's very moving and educational. So personally, that's why I think eventually the law will change in every country in the world because of individuals coming out to their families. What will take longer than changing the law is changing the doctrines of religious groups. So at the moment in the UK, the Church of England, the Roman Catholic Church, and most parts of Judaism will not marry a same-sex couple. So that will take a long time to change. But so the issue for the moment is the secular same-sex marriage, where a child says, we're getting married at the local register office. Do you want to come? So, okay, thank you very much for your attention. I welcome your comments and questions.